Hi everyone, and thank you for joining us today on our segment for a guide to identifying and preventing financial elder abuse. My name is Alyssa Chow, and I'm an attorney in the Sacramento area, and I'm also joined by Brian Jeremiah, who is also an attorney in the Mather area, but he does provide services in the greater Sacramento area, and he'll explain a little bit more about his practice and where he provides legal services. All right, so a little bit about me. I'm the owner attorney of my own firm. I do provide legal services in the area of trust and estates, primarily in the Sacramento area. I did grow up in the Greenhaven Pocket area, went to McClatchy High School, left to go to UC San Diego for undergrad, and then came back to Sacramento to go to McGeorge School of Law, which is actually how I know Brian. We were both classmates at McGeorge. Part of my practice does focus on estate planning, but I also do trust administration, probate administration, and conservatorships as well. I've been a part of ACC for many, many years. When I was growing up in high school, I would volunteer pretty frequently with ACC, and I've also volunteered mostly pre-COVID, but volunteering a lot with the various activities and events that ACC puts on. And if anybody will be at the Ohana Walk coming up on Saturday, I'll be at one of the checkpoints representing Sacramento Asian Sports Foundation, where I'm also a vice president and secretary.
Hello everyone, I'm grateful to be here today, and thank you Alyssa for inviting me. My name is Brian Jeremiah. I grew up here in Sacramento. I'm a proud Sacramentan, graduated from Jesuit High School in 2002, went to Loyola Marymount University in Los Angeles, graduated in 2006, and then from Pacific McGeorge School of Law in 2015. Was glad to cross paths with Alyssa. And I think we've actually come to know each other a bit more even after college, kind of through our crossover through work, which has been helpful for me. So
Yeah.
I'm glad to be here.
Yeah.
A little bit about my law firm, which is called Hackard Law. And you can see a picture of the owner of the firm at the top. That's Mike Hackard, who is also my father-in-law. So it's a family business of sorts. Mike has been practicing law in town for decades, so I'm learning from him. I've been with the firm for 5.5 years, and we focus broadly on trust and estate litigation with a specific focus on elder financial abuse, which we will discuss more specifically. What you're looking at here is a screenshot of our YouTube channel, which has over 750 videos on it that Mike Hackard has written and produced, and they are a wonderful resource for people who are encountering issues with regards to trust and estates. I think most of all topics are covered there, so feel free to check those out if you have further curiosity. An additional resource that Mike has been generous to provide to the public is a book on the topic of elder financial abuse called The Wolf at the Door. And I think Mike wrote this 4 or 5 years ago, and it's written in a way that's intended to be consumed by lay people. And it's a really great breakdown of the law, but it's also filled with many stories that show the practical implications of what occurs during an elder financial abuse case and what can be done about it.
I've got my copy. I should probably ask him to sign it for me next time I see him.
He'd be happy to do it.
Yeah. All right, so we're going to dive right into it. Brian's really going to be the expert in this field. He primarily does practice in the litigation area. I'm coming at it more from the estate planning side, so we're both just going to be kind of walking you through what you can expect and ways to identify and hopefully prevent financial elder abuse.
Great, so just a few slides here kind of setting up the problem. And I'll just call out one stat from this slide, which indicates that 10,000 baby boomers will turn 65 every day until 2029. And the reason that's important is because the age of 65 is when you become a elder for purposes of the elder financial abuse statute. And so from a legal perspective, that's when you gain special status that could give you legal standing to pursue an elder financial abuse claim. And so the scene is set for many people to enter that class, and will give rise to claims over the next several years.
It's a lot of people.
Sure is. And with that, you have folks turning 65, but also you have people living longer than they did before. And this is great in many occasions, and unfortunately, oftentimes it can cause challenges, obviously for the elder person themselves, as they experience different health problems, and primarily with regard to their cognition. It's just a fact of life that as you age, there's a normal cycle of deterioration, specifically with regard to your brain, and it can be exacerbated by many different factors, and creates this foundation of vulnerability, which people will take advantage of, which we can speak about further.
Yeah.
And more specific to the point, and most of you will be familiar with this, the concept of Alzheimer's and dementia, and the general cluster of symptoms that arise as you age with regard to memory loss, confusion, delusions, brain fog, trouble with executive processing, things to do with planning and logic. And so you have this deterioration, which again can make someone vulnerable to being taken advantage of in many different ways. And the way we're discussing today is with regard to their finances. And there are myriad ways which a bad actor could get entangled with an elder in order to swindle them or trick them or straight out steal from them.
Mm-hmm. And we're on the lookout and just on guard for that constantly in our practice.
Definitely. And you, Alyssa, on the planning side,
Yeah.
have a specific radar for that, which I'm sure you'll discuss as we go through here.
That's the perfect way to put it. I'd say radar is, yeah, what's going on. All right, so what is financial elder abuse?
Yeah, it's a good question. And we have here the kind of simple question and answer. What is it? Well, the answer is it is stealing from an elder. And it could be money, it could be personal property, like the actual things. It could be their real estate. It could be a right that they have. So just broadly speaking, it is stealing something from an elder.
And we're gonna talk, kind of touch on the more legal side of it and then dive into some examples in a little bit as well about what that actually looks like from a practical perspective.
Right, so of course when you get into legal issues, we just talked about the simple answer, and then it gets more complicated and convoluted with the way that statutes are written. And so we'll take a look at just a few phrases from the statutes that define what exactly is elder financial abuse. And of course the statute doesn't use the word steal, instead it uses the word takes, taking from an elder. And that can be taking real or personal property from an elder. And then you've got three different ways that this taking can occur. And the taking can be for a wrongful use with the intent to defraud, or by undue influence. And each of those terms has its own convoluted definition and myriad ways of which they can be carried out. Oftentimes, someone can take from an elder by doing all three of those things. They can intend to defraud an elder, take their money, use it wrongfully, and all of that together can also be undue influence. So at times, you don't really need to parse this all out. And there are times too when you don't even need to bother reading all these specifics, because you can just tell that something bad happened and that someone was taken advantage of. And as we go through, we can discuss some examples, and I'd be happy to provide them whenever you'd like me to.
Yeah.
An add-on to the definition is that someone is deemed to have taken something from an elder for a wrongful use if they knew or should have known it would have been harmful to the elder. And this is another one of these kind of soft definitions. Well, what does that mean? Well, you'd like to think that if there's an elder who's experiencing symptoms of dementia, that a thoughtful person wouldn't want to take their money or convince them to transfer their house to them, or change their trust to give 100% of their assets to them. You'd like to think that most people know when they are taking advantage of somebody. Unfortunately, that's not the case. And of course, there's often the category of people that know what they're doing is wrong and they do it anyways.
Yeah.
So let's get a little bit more specific, and this is the focus of my law firm's practice, and this is focused on a specific type of taking from an elder that people often don't think of at first blush. And the code defines a taking by depriving an elder of any property right, including by means of a testamentary bequest. And so what this means is all individuals have a right to devise and bequest their assets as they wish. And so Alyssa can elaborate on this at some point, but they have the right to write a will, to write a trust, and direct what happens to their asset. That is their right. And that right can be interfered with by a bad actor. And that interference can be elder financial abuse. And so where this comes into play is the field that's commonly referred to as will contests and trust contests. And this is where you have an individual who, say, for a very long time had a trust. And that trust distributed their assets equally between their 3 children. Common scenario. And then later in their life, say when that person is experiencing some issues with their cognition, or maybe has even been diagnosed with Alzheimer's, and may have another set of physical ailments that are causing problems for them, you suddenly see that there's a new trust or an amended trust that eliminates the equal distribution and instead gives 100% of that person's assets to maybe just one of the children, or a neighbor, or a caregiver, or another relative. And there are plenty of circumstances where this could be completely benign, and it's absolutely what the elder wanted to do. But unfortunately, there are also plenty of circumstances where this is not what the elder wanted, and there was wrongdoing involved. And that's what gives rise to a claim for elder financial abuse.
Yeah, you mentioned earlier that, you know, for someone like me as an estate planning attorney, I'm always looking or have my radar sort of trying to determine whether something like this is happening. And it's really hard to detect, especially if you don't know someone for a very long amount of time, right? Maybe somebody just calls me up out of the blue. We set up maybe 1 or 2 meetings. It's really hard to identify during that time whether someone's being taken advantage of. But it's not uncommon where I'll be called by, for example, the adult child or one of the adult children, and that person says, well, you know, my mom has early onset dementia. She and my dad created a trust 20 years ago, and now she wants to change everything so that I'm in charge of everything right now. And, you know, a number of other instructions that vary wildly from what the trust already says. Immediately, alarm bells are going off in my mind. And so that's something that all estate planning attorneys are looking out for. purely because we are concerned about things like elder financial abuse, and whether or not something that we may do as far as updating documents may result in that person effectively taking the client's money or assets.
And we could discuss some other common examples of elder financial abuse. We already discussed changing a will or a trust. But another common one is influencing an elder to transfer ownership of their property. We deal with a lot of these deed cases where out of the blue, there's been a new grant deed recorded against the property where the elder gives away their ownership to, again, it could be one's child or a neighbor or a caregiver or anybody else. And there's a reason to question why this transfer happened. And oftentimes the scenario is the elder, worked their entire life to have this home and maintain the mortgage payment, and finally it's all paid off, and it's clear from their estate plan that they'd like it to be split equally amongst their children, and there's really no good explanation as to why it's transferred to one person. And so one way to reach a remedy would be to file an elder financial abuse claim. There are other associated claims, but that's one of them.
Yeah, I've heard before where people have come to me concerned, and then I refer them to you, but people who come to me concerned and say, one of my siblings just passed a document over to mom, had her sign it, and then a notary came and notarized that document, and all of a sudden this property is in my sibling's name. How did that happen? Or I've had somebody contact me as well who said that their older sibling who had something like a power of attorney for their mother actually deeded the property to themselves using that power of attorney. And so, it's really unfortunate when things like that happen, and it totally results in the breakdown of all of the relationships among family members as well.
Yeah, that's a good point about the sliding the paper over and sign it,
Yeah.
especially when it comes to deeds, because it is a one-pager most of the time. And unfortunately with deeds, there's no vetting of the deed on the front end of the process. Oftentimes an attorney's not involved. They're pretty easy to prepare, to find online, and it would be very easy to slide it over and say, hey, and we hear this often, this is just something you need to sign for your taxes, or this is something to help me work with your bank or something like that.
Right.
There's no explanation. The elder, again, maybe cognition problems, but also maybe has trouble seeing or hearing and can't even read the document, or maybe they don't speak English and nobody's translating the document for them. So yeah, with those one-pagers, that's a particular problem.
Yeah.
Other kind of categories of cases that we see a lot is when someone uses their authority, you mentioned power of attorney, to change the beneficiary of a life insurance policy or any other account that has a beneficiary on it. That's very common. One anecdote that comes to mind wasn't a case that I worked on personally, so I kind of just had a front row seat to it. But it was a case like this where someone's wife, she was the second wife, so she called the company that held the insurance policy and pretended to be the husband. Ooh. And we got the recorded calls.
Oh, no.
And it was painfully obvious that she was impersonating him. And thankfully, the call operator sniffed it out during the call. And it was very interesting to listen to that. I mean, it's sad and unfortunate, also comical. And ultimately, we were able to, resolve that case using that evidence in a deposition with this person.
That's awful.
Yeah, so that's a really egregious case where it happens kind of directly and gets sort of caught in that way. Typically, that's not the case.
Yeah, that's incredible.
And then kind of the more run-of-the-mill garden variety would just be using somebody's authority to simply withdraw money from an account. And of course, we see that all the time.
Yeah.
kind of a recent, more egregious example of this would be an individual who had a power of attorney for his mom, and she was kind of experiencing all of the things we've talked about. So cognitive decline, had a serious hip injury that necessitated a long surgery. She was in her early 90s. And again, have records of phone calls where her son, who had the power of attorney, was contacting the financial advisor to request large withdrawals, like up to $800,000. And he told the financial advisor that it was for his mom's debt consolidation. The problem with that is that mom had no debt, which we were easily able to verify through other financial records. And nonetheless, these withdrawals were authorized, unfortunately. Anyway, son, who had the power of attorney, 2 days later used that money to purchase a home that was in his name alone.
Yeesh.
So you have a period of about a week where he's using his power of attorney, gets mom's assets, and flips that into a home that's just his, to the detriment of his siblings. So those are some recent real-world examples of how this stuff happens.
Yeah. Do you find that when you're looking through records that people start out small to test the waters and then do bigger transactions, or do people just dive right in?
I would say in these types of cases, and which it's good to know, these would be kind of classified as sort of accounting cases, whether that's an accounting of somebody acting as a power of attorney or as a trustee of a trust. They are obligated to produce accountings. And so that's what we're discussing when we're looking through records. We get an accounting, which is a line by line itemization of transactions. And then in the best case scenario, you also get the bank records that support that. And so in certain cases, we look at a lot of these records. I wouldn't say I'd see that pattern exactly. It's more just a mix. But you do see clusters of things where they just kind of go to town.
Okay.
And in this particular case, with the withdrawals ostensibly for debt consolidation, that case also had a number of other transactions. You know, while mom is incapacitated in, say, a memory care facility, her power of attorney son is buying, tickets to concerts in Tennessee. And
so clearly not
things
for her.
like that. Clearly not for her.
Yeah.
And maybe putting cart before the horse here, but getting into the kind of litigation of these matters, the son's defense was simple and was simply, well, that's what my mom wanted. She wanted me to use all of her money for, my own enjoyment. Well, the problem with that is that the history showed that she actually wanted to split all of her assets amongst her 4 children and not just for the one son. But that's his defense, and we can work that out. So,
Okay.
Yeah.
All right. Yeah. And then what about undue influence?
So thinking back to the definition of elder financial abuse, where you have it occurring in 3 different ways: for the wrongful use with intent to defraud, or by undue influence. We're going to focus a little bit on undue influence, which is kind of a shifty term and a little bit hard to define. So we're going to kind of break it down, define it some, and then we can talk some more about it, because this is kind of where the crossover comes with regard to estate planning and then litigation. And so the legal definition of undue influence is excessive persuasion that causes another person to act or refrain from acting by overcoming that person's free will and results in inequity. And so basically it's forcing someone to do something against their will. But forcing isn't quite the right word, because it's not an overt force. It can kind of happen quietly over a period of time, or it can occur by way of sort of quiet manipulation or subtle manipulation. It's not a blunt force act that you witness, in one moment. And so refocusing some on our firm's focus, on these will and trust specific contests. A will or trust that is procured by undue influence is invalid. And so if someone creates or changes a will or trust that was created under the influence of someone else, you can file an action in court to completely invalidate that document. And again, that's what our firm focuses on. And then to kind of put more flesh on the bone for undue influence concept, when you're thinking, well, what is undue influence and how do I determine if it exists? Well, the statute defines for us some things to look at. And there are 4 of those things. Those are the vulnerability of the person being taken advantage of, the quote, apparent authority of the person doing the influence. And what that means is the person influencing has to have some sort of trusted position in the elder's life, such that the elder would look to them for their help and guidance. And these are people like children and caregivers and neighbors and lawyers and doctors and you name it. And so that's what gives rise to this phrase of apparent authority. And again, such that the elder would look to that person and not ever expect to be taken advantage of by them. And then, of course, you have to have actions and tactics. The person actually has to do something, do something wrong. Because you could, of course, envision a scenario where, let's say, an elder wants to give their assets to their caregiver. That is not in and of itself against the law. It raises all sorts of suspicions that there's a problem, but it is not per se wrongful. And so in a case like that, the caregiver, you would still need to demonstrate that they had some involvement in procuring this document.
Right.
And you show that in different ways, which we can discuss. And then last but not least, there has to be some unequal result. And that is highly dependent on the circumstances. But the easy way to think of it is, as we discussed before, the formerly equal split among 3 children to giving everything to one child. That's an unequal result. But again, you have to prove all these other things. That alone is not sufficient to show that there was wrongdoing. And so here we get to a legal maxim, and there are all sorts of these that have developed over time, and this is a good one. And that is that undue influence normally takes place behind closed doors. And maybe, Alyssa, this is a good one for you to address from your side of the aisle when you're trying to assess whether or not there's a problem.
Yeah, I would say, a couple things that I'm always looking for when someone contacts me to update their documents would be, do they have one child who lives with them now? Maybe they do have 3 children, but one has decided to move in, become a full-time caregiver, or in some cases, we say caregiver somewhat loosely because they're living in the home, but perhaps not actually doing anything for the parent. But we sort of see that that child has wormed their way in to taking over all communications for their parent, managing all their mail, maybe monitoring their email, or doing other things where their parent really isn't in control anymore, and they have convinced their parent, or perhaps the parent is, like you said, they're very reliant, right? They're in a position where they couldn't expect their child to take advantage of them, but they get to that point where the parent just is completely fine with it. They see nothing wrong with the fact that the child has the reins, and they think that they have their best interests at heart. But really, the more that I get a little more information from the estate planning side, it does start to raise some red flags. And at least in my practice, I insist on meeting only one-on-one with the client, because it's also not uncommon where if somebody, if you and I are sitting together with an attorney and the attorney asks you a question, and I go, oh, well, we did this last week, or, oh, well, that you wanted this, right? And so when you see that happening more and more, even in a very sort of general way, when you're just having a get-to-know-you conversation with someone for estate planning purposes, it does become very apparent that there's some groundwork that was already done before the client came into the meeting, so to where the client or the prospective client is already used to that treatment and very much relies on their child now to dictate how their interactions go with other people.
That's a good word, groundwork.
Yeah.
And I'll set one up and ask you as well, because I'm curious for you. I think in terms of groundwork, and you could look at it too as a different type of grooming. And grooming is a term often used, with regard to kind of sexual abuse or harassment. But something that we see often is, so say we represent a child who has been disinherited from a trust. And that client tells me, hey, my brother has just been bad-mouthing me to our dad. And he's making up all sorts of stuff about me, saying I'm irresponsible, saying I'm into drugs, X, Y, Z. And it's either not true, or it's exaggerated, or it's a deliberate plan to get dad to cut out son. And so the question would be, when you have a client who's saying, I want to disinherit Bob because Bob's a drug addict, what level of investigation or due diligence is appropriate there?
I mean, so as much as I can get the client to explain the history, right? Explain what the family dynamics are. Has there always been a strained relationship, or is this a relatively newer thing that's popped up? And just, as far as timeline goes, did it just so happen to coincide with when that one child moved in, right? So there's ways that you can start connecting the dots. And as estate planning attorneys, we don't like to turn away clients, but if we're really concerned about the fact that if we're concerned that we think that client is being unduly influenced in drastically changing their documents or setting things up where, again, it's just not really lining up, then I have no problem stepping away and saying that I don't feel comfortable doing those documents for the client. But as much as I can, that's why I really do like to meet one-on-one with the client, so that they aren't looking for that validation related to all that groundwork that may have already happened before they came in to see me. So it's the really amorphous "it depends" response, but as much as I can get the client to explain what's going on, and specific examples too, right? I'm looking for specific examples for maybe an event or something that happened that started the bad blood, or the other thing is that I'm trying to find out, is the bad blood only between the siblings themselves? And if so, I try to remind the client that these are the client's documents and it's the client's money. So regardless of how the siblings feel about each other, the client is the one who gets to decide what ends up in their documents at the end of the day.
So this is an add-on to the prior slide as to how you prove an undue influence case. Proof of undue influence is by circumstantial evidence most of the time. As I said before, it's not this blunt force, painfully obvious act of influence. You know, it's not somebody standing over the shoulder, holding the pen to sign the document.
Right.
It's all the stuff that happened before, outside of the presence of an attorney. It could be over a period of years, you know. Oftentimes these cases pull in evidence that span decades, involve several family members, several witnesses, neighbors, friends, advisors.
Maybe even APS here and there.
Yeah, APS is often involved because they get called out when there are suspicious circumstances. So we look at a good deal of APS records in these cases. And so when it comes as a litigator who is pursuing a case like this, it's a wide net as to what could be relevant in the case. And oftentimes the primary evidence is actually the file of the lawyer who drafted the trust. And that's because it's the most directly related information to what happened. You know, so if the crux of our case is elder person changed their trust, well, we need to know everything that happened about the change to the trust. And so in California, the plaintiff pursuing the litigation has the right to get the drafting lawyer's file as part of the discovery process. And so we spent a good deal of time doing that, and a lot of the information does lie there that helps to frame these types of cases as to whether they're strong cases or not strong cases and what actually happened.
Yeah, because kind of like the slide here says, once the person has passed away, they can't testify as to what happened.
Yeah, it's a bummer. The one person you truly need to hear from is no longer with us.
Or if they're still alive but maybe incapacitated now.
Exactly. Yeah, the vast majority of these cases are pursued after the elder passes away. There's a small subset of them that occur while they're alive, but you've identified the problem. That's typically when they are already incapacitated. And often the fight in those cases then becomes actually, is the elder incapacitated or not? And those types of cases are especially challenging because if the elder is incapacitated, then you have potential to right a wrong. If the elder does have capacity, well, then you've just sparked a whole set of problems for your family because you have just filed a lawsuit saying that your parent was out of it, and as it turns out, they're not out of it. And so those ones require a very specific analysis as to whether or not to do anything.
Yeah, we refer to those as dumpster fires.
And this issue about the person you need to talk to not being alive is interesting. I once attended a workshop for trial lawyers that was attended primarily by personal injury lawyers who did like car accident cases and things like that. And I was going through their program, and I was standing up in front of a group of fellow lawyers kind of workshopping a case and laying out the facts. And this particular method requires you to like act out scenarios to help you inhabit your case. It's a very interesting process, and I actually kind of had the group sort of riveted because they do car accident cases, and here I am talking about grandma and the sons, and it's very interesting. And one of them, let's say we're talking about grandma's trust who passed away, one of these lawyers like very inquisitively said like, well, what does grandma have to say about all this? I paused and I said, well, that's the problem.
Right.
Grandma's not here.
The most important person.
And so that highlights, one unique part of our field is that we are, by the nature of what we're doing, we're kind of, is a moving target. Like we're never gonna know exactly what grandma wanted, but we have to do our best to put the pieces together. And that's what gets to the circumstantial evidence. So getting more specific, on the elements of a claim, the first one is vulnerability of the elder. And I've identified a number of factors or characteristics that can exhibit vulnerability. And oftentimes you see all of these: incapacity, illness, disability, age, education, language barriers, etc. Again, you might just have a few of these to point to, but oftentimes you're dealing with an elder who, say, is in their 80s or 90s, and just, by the nature of life, you accumulate some of these characteristics as you get older. Mm-hmm. I've mentioned this a number of times already, but kind of the common folks involved in these cases are caregivers. They have access to the person, neighbors, relatives. At times you get professional advisors who are intermingling a little bit too much in someone's situation and can find themselves in a gray area. And then other trusted officials. I recall one circumstance where actually I was doing estate planning at that time. So I was in your shoes, and a woman brought in an elder to our office, and on the front end it all seemed very safe and benign, but as it turns out the red flags started to go off, and the person who brought in the elder was a worker at a vet office. Okay. And like a tech at the veterinarian's office, and as she was explaining her involvement with this elder, I kind of think, well, I don't know why you're so involved.
Right.
It's a very nice thing of you to do, I suppose. However, when it starts to come up that this veterinarian technician is going to be a beneficiary of this person's estate, I don't know.
Right.
That might be totally fine. But again, alarm bells and red flags,
right.
And you have to make a judgment call.
Totally.
Yeah.
Yeah, so I guess we can talk about some of the different actions and tactics that we see, or that on your end, right, when a lawsuit has been initiated, what are some things that you've seen have happened as far as when an estate plan has been changed? Or I guess that would come out through testimony or other discovery.
Yeah, and these are multifaceted. There's several actions and tactics that one might take in these cases. So trying to kind of limit them to a list is difficult.
Yeah.
Some of the common ones that we jump to immediately would be, did this person, so let's say we're talking about a mom and her son. In the scenario of, let's say, son moves in with mom late in her life, ostensibly to help take care of her and these things. Some initial questions as to a change in the trust would be, well, was it the son who called the lawyer and set up the meeting? Did the son attend the meetings with the mom and the lawyer? Did the lawyer speak directly with the mom? Or was the son kind of directing the meeting?
Right.
Whose email was provided to the lawyer? I see that one a lot, where the lawyer receives the son's email to communicate. And on the one hand, that could be fine, right? The elder might not email. That's legitimate. But I've also seen it where you had all these. So you had son contact lawyer, son provide son's email, the drafts get sent only to the son. And it was so blatant as son emails lawyer, hello, mom would like to change her trust to give everything to me.
Right.
And then the draft goes to the son to confirm, yes, this is what mom wants. That's very blatant.
Right.
But I've seen that scenario.
Yeah, and then the question there is, well, then who's the client? Is it the son who's now dictating what happens with mom's assets? Because that's not right either.
Exactly. Yeah. So that's a more direct action or tactic.
Yeah.
But the more subtle ones are the ones, again, that happen behind closed doors. And these are things like bad-mouthing other siblings, isolating the elder. This is very common. Sort of managing who can visit the elder. Again, taking the scenario of the son who's home taking care of mom and telling his sister, it'd be great if you came by today, but mom is just so tired. She had a doctor's appointment. Why don't you check back next week?
Right.
And then that pattern persists for months and years even, and suddenly it's been a few years since mom has seen her daughter.
And then from mom's perspective, it seems as if that daughter doesn't care about her anymore.
Exactly.
Or isn't trying to maintain the relationship in any way.
Right, and that's where you have mom come into a lawyer's office and say, you know what, my daughter, I don't want to leave her anything. She hasn't been that involved the last few years. My son's been home with me. And then, suddenly you've got to change.
Yeah.
And so that's a very subtle occurrence of undue influence that's hard to pin down.
Yeah.
And so other aspects of control of the elder could be controlling their medication or their food, things like that. Yeah.
And I know there's tons of other things that happen, maybe not necessarily with family members or people who are close to the elder, but there's all kinds of scams and other ways that people could be easily taken advantage of, right? So.
Yeah, we've got a list of those here, and these are the ones you kind of hear about more just in like common conversation, which would be like phone scams or email scams.
Right.
And these are really common.
Yeah, the grandparent scam, if this is the one I'm thinking of, I actually had somebody came in to tell me that it didn't happen to them, but it happened to someone that they knew, where a grandson called the grandparent and said, I'm in LA, my bank accounts have been frozen, I need you to send me $1,000. And to the grandparent's credit, she said, well, what are you doing in LA? You don't even live in California.
Yeah.
So she picked up on it very quickly. But this person had her full, knew certain things that only a grandchild would know. She was quick to pick up on it. But something like that, I'm sure, if you're a grandparent and you say, sure, of course, let me send you some money. And it's all a numbers game for them. They're just looking to try to find, these scammers are just looking to try to find as many people who will, kind of take that bait.
Exactly. And many in this category, unfortunately, don't rise to the level of litigating. Often it's like a smaller amount of money involved, and so maybe there's some sort of small claims case.
But just some things to be aware of.
Yeah, just something to be aware of, and something to identify as maybe a precursor to these other kind of things we're talking about. If your parent or somebody you know is getting taken advantage in this way, okay, well, the scene is set then for other circumstances.
Yeah.
Yeah. Here's some more things to look out for when you're trying to spot, whether there's potential for financial elder abuse to occur or be occurring. And then you've got unpaid bills, kind of unusual or unfamiliar signatures. You have a sudden change to a power of attorney or an estate plan. Again, isolation. One that comes up all the time in our cases is the baby monitors getting installed. And there's two sides to every argument, but the two sides of the baby monitor argument is that the son taking care of mom says, well, yeah, of course I installed baby monitors because mom was a fall risk. And she had fallen once and I wasn't home to be able to help her, and so we put monitors in so we could keep her safe. Well, that's pretty reasonable. Of course, the other side of it is this would be, my client saying that this was all part of the isolation and the control and wanted to make sure that nobody was visiting, or if they were visiting, so that they could listen in onto what they were talking about.
Right.
And there's a kind of spectrum there as to very valid concern, very well could be part of control, to then bordering on kind of conspiracy theory, and
Right.
maybe that's my own naivety, because I would never do that.
Right.
But there are people out there that do that, and so the baby monitors and the call recording is a very common thing that comes up.
Yeah, and it goes back to, you've mentioned it a few times, but that control, right? This person, whether a family member or someone else close to the elder, starts slowly taking over control, and it just goes back to what we talked about before too, which is that groundwork of them having all the information that the elder otherwise would have on their own, and then starting to sort of pull the strings for how that information is used.
Right. So the last factor of an elder financial abuse case based on undue influence is this equity of the result. And we talked a little bit about this already, but the primary issue here is this first one identified, which is diverging from the person's prior intent. And so the classic case would be somebody who had an estate plan for 40 years. Again, equal split among the kids, and then 2 months before they pass away, there's Alzheimer's, maybe they're in a nursing home or something like that. There's a new document, again, giving it all to one child. It's questionable. At the very least, it's questionable. And so that the mere fact of the divergence, it could be evidence of the equity of the result.
Whereas there's some situations where I've seen, maybe somebody comes to me and they had a document that was 30 years old, and they always intended for one child to always get their house, right? And as long as they're consistent with something like that, let's say they sold the house, and so they say, well, we don't have this house anymore, we live in assisted living, and so we want to make sure that the cash value of that would go to that child. Then at least if we're looking at the old documents, it's still consistent, right? The intent was always there, it's just in a slightly different form.
Yeah, that's a good point. And we see that a lot on the front end when we're talking to potential clients, where they see a recent trust amendment, say, and it's not uncommon for people to amend their trust a lot, like more than you would think. Like you could have every couple years maybe an amendment.
Yeah.
And so a client might reach out to us and say, hey, I see this Fifth Amendment. I'm not in it. Okay. We gather documents from them. Ultimately, we see the amendments 1, 2, 3, 4, and 5, and we have to say to them, "Well, I'm really sorry, but actually, you haven't been in the trust
for years
since 1994."
Yeah.
And so I'm sorry. This is beyond the scope of what we can assist with. But that's a good point. The second one is really important too, and that's the relationship of what's conveyed to the person to the value of the services they provided. Staying on the son's home to take care of mom, well, that is a valuable service for a family. And you could definitely understand how the parent might want to compensate that child more than the others. But if that service was only for a month, or wasn't actually any good service at all, well, then giving them the whole house, it doesn't balance out with what they provided. This comes up on these deed cases that we talked about, where you have the quick sign over of the deed. And the defense argument is often something like this. Well, she wanted to give me the house because I was going to help her take care of it. Well, okay, that's a nice service to help someone take care of their house and stay on top of bills, but does it equate to actually owning the house? I don't know.
Especially if in the context of the person's estate or the value of what they have, really if the house is the only asset and there's maybe a checking and a savings account with a couple $1,000s, that's another red flag that gets raised.
Right.
Yeah. All right. So what can people do?
What do we do? All this doom and gloom of all these
know.
bad people out there looking to prey on elders. Well, what can we do? Again, you've got this kind of spectrum of where you are, and the front end is on the planning.
Yeah.
And maybe you could speak to kind of best case scenario with planning to prevent things. And I
Yeah.
could poke holes in it. Since that's
I
what
know,
do.
yeah. We're each other's worst nightmare.
Yeah.
So, I think something that is very common on my side, which we've touched on earlier in the presentation, but, I personally really insist on meeting only with the client one-on-one. So family members, if there are family members who are trying to help coordinate meetings for estate planning purposes with an attorney, just understand that the attorney themselves is not trying to cut you out of the conversation. It's really more to protect the parent or the client, whoever it is whose documents we're doing. We're trying to make sure that it's as clean of a record as possible to show that that's exactly what the person wanted. So, sometimes I'll have irate conversations with irate children who are upset that I tell them they can't be in the meeting. Maybe, yes, you can drive mom to the meeting because she can't drive anymore, but you are not going to be allowed in the meeting itself. That I think if family members are a little bit more understanding that it's their parent or the elder's, choice for whatever they want in their documents, and that they are the most important person in the room, meaning the elder in that situation, then I think that can go a long way to making sure that we can get as close to what they wanted as possible. So that's the most I can do on that end. And I like I said, I've turned people away, and I've had it, unfortunately, also then been contacted later to be told that the elder ended up at maybe like a legal document preparer or someone who wasn't an attorney who just drafted something up for them at the direction probably of that same child who initially called, and then now there's a pending, the attorney general or somebody's involved now. They're concerned about elder abuse. So, long-winded way of just saying, the person whose documents I'm doing, they're the most important person, and respect that relationship between the attorney and that person.
Yeah, a few comments there. I think you could have the very best estate plan with the most thoughtful preparation, all of the safeguards,
right?
All of those things, and it might still not prevent someone from acting improperly.
Yeah, absolutely.
So it's not a perfect process, but there's kind of best case, and from my perspective, that's the things you've described. Plus, and I know that you do this, is full documentation of what you've done, the reasons provided by the elder, and this is most pertinent again to disinheritances. Why did you want to disinherit your son? Well, one line in your note that says, haven't talked to son in 5 years. From a litigator's perspective, like, that's not enough.
Right. What does that mean?
What does that mean?
Yeah.
Do you have a specific memory of the last time you spoke? Was there a problem? What else have you heard about your son? These kind of things. Because again, when I'm scrutinizing, say, Alyssa's file on a case, those are the things I can look at when I'm building my case as to this person really didn't know what they were talking about. They just showed up and repeated something that somebody had been putting into their ear. So full documentation, identifying why the person is making these decisions is very, very important. And then you brought up a good point about legal document preparers. This is something in the law that is permitted. People can become a legal document assistant, I think is the term in the code. And they are specifically permitted to prepare templated estate plan documents for people. And the theory behind this was to provide a low-cost alternative for people to get estate plans done if they can't afford an attorney, which is a good concept. The problem is you have people churning out templates, and the problem with the way the code is written is that the people preparing them are not permitted at all to give any sort of commentary or advice about the document they're preparing. It's just a churn.
Right, just basically plugging in facts or whatever information is that's provided.
Right, so you might well have the bad actor, say the son, show up with mom, communicate everything to the document preparer,
Yeah.
and then boom, you know, a couple of days later you have a plan.
Right.
So we see those often.
Yeah. Okay. Well, yeah. So that pretty much covers everything as far as today goes. Thank you so much for being here today, Brian. And I don't know if anyone had any questions or if they submitted any into the chat, but Brian is available to, if you want to contact him for any questions, if you're concerned about someone who may be a victim of elder financial abuse, or if you have any other questions about the process.
Yeah, thanks for having me. Happy to answer questions now or later. And those are just the other people at our firm.
All right. Thank you.